Over the last few years, there's been a significant increase in the amount of construction activity in Florida. And you have these developers who are typically entering in construction contracts that are proposed by their general contractor clients. And oftentimes, those forms unfairly shift the risks that can arise on a project to the owner. And these owners are strongly advised to have an expert in construction law review these construction contracts to modify them to more equitably allocate the risk between the parties. Even if the parties are using a standard AIA document, they are still advised to review and modify them in order to make sure that they comply with Florida law, Florida statutes, and to address project-specific issues. For example, in the AIA documents, the indemnity provision is arguably unenforceable under Florida Statute 725-06. Another result of the increase in construction activity in Florida is that you have premier subcontracting trades being able to be more selective in which projects they are going to work on. And as a result, they are pushing back on the more onerous provisions that are in their standard subcontract forms with the general contractors. They're able to use their long history of high-quality work to leverage better terms in those standard subcontract agreements. And conversely, general contractors now are unable to always use their first choice of a subcontractor, and as a result, they are sometimes forced to use a lower quality sub, which has a greater likelihood of defaulting on a project. And these general contractors are strongly advised to revisit their own standard subcontract forms to make sure that they protect themselves against such a default. The goal of a well-crafted construction contract is not just to win a fight if one arises on a project, but rather to avoid the fight altogether, because the parties have already discussed the issues and agreed on how to allocate the risk of these various contingencies.